Well, good morning. I am Degendra Rana. The topic for our discussion today is the doctrine of privity of contract. The doctrine of privity of contract. So, the doctrine of privity has traditionally represented the principle that only a party to a contract can enforce a benefit or have burdens imposed on him under that contract. So the restriction on a third party being able to enforce a provision which was intended for the benefit meant that the intention of the contracting parties could be thwarted and the reasonable expectations of the third party denied by the doctrine. So this necessitated a series of technical and sometimes artificial methods of evading the strict application of the privity rule. Also, a number of statutory exceptions were required to circumvent the doctrine in areas of commercial practice where its applications was extremely inconvenient. So let us say the general principles of privity to a contract and the exceptions to it so that we may ultimately examine how the doctrine of privity and third party rights operate with respect to insurance contracts. A general exception to the doctrine for all contract is provided by statutes, but there are other narrower statutory exceptions which were introduced to avoid the commercial inconvenience caused by the privity rule, for example, collateral, contract, assignment, etc. So specifically for insurance contract, the usual method if the insured wishes to extend the benefit of the insurance to a third party is to contract not only on his own behalf but as agent for third party, in which case the latter is a third party, no longer but a party to the contract. In certain situations, Parliament has intervened and given the third party a statutory right of action on the policy. So, privity of contract and third party rights general principle says that the doctrine of privity of contract has been long established yet controversial. It represents the principle that only a party to a contract can enforce rights or have duties enforced against him under the contract. So a party to a contract is one to whom a promise is made and who in exchange for the promises gives consideration for it. So the traditional view has been that a promise who is promised some benefit but gives nothing in return cannot enforce the promises. Similarly, that a beneficiary of a promise who is not the promisee and who provides no consideration cannot sue on the promise. So the principle developed in the common law courts in England was not crystallized in the case of Dunlop Pneumatic Tires Company Limited versus Selfridge and Company Limited, in which Dunlop sold some tires to Dew & Company on the terms that Dew & Company would not resell them for less than the Dunlop's list prices, and that Dew & Company would insist on the same undertaking from the trade buyers. So Dew & Company sold the tires to Selfridge, who agreed to conform with this restriction, and in the event of breaking the agreement to pay Dunlop £5 for each tire sold and each of it. So Selfridge later sold the tires to customers for less than the list price and Dunlop sued Selfridge for damages. So the House of Lords dismissed the action and affirmed the doctrine of privity authoritatively by stating that only a person who is a party to the contract can sue on it. So a right cannot be conferred on a stranger to a contract to enforce the contract of personam. The judges said that a second principle is that if a person with whom a contract not under seal has been made is to be able to enforce it, consideration must have been given by him to the promissory or to some other persons at the promisor's request. So the statement rests on a principle of mutuality to the effect that it would be unfair to allow a person to sue on a contract who cannot be sued by the other party. So gradually, for reasons of commercial convenience, there was felt a need to recognize the third-party rights. In 1937, the Law Revision Committee in UK recommended in its sixth interim report that a third party should be able to enforce a contractual promise received by another for his benefit in 1991. So as far as the fact that a series of ingenious, the series of devices were restored to by the courts together with a number of established common law and statutory exceptions to the doctrine to avoid injustice in many cases did not negate the case for reform. So the various exceptions to the evasions of the basic rule merely served to demonstrate the impracticable and unpopular the doctrine of privity had become, and this was reflected in the strictures of the judiciary. Now, statutory recognition to third-party rights. It was much later that third-party rights in a contract were given clear recognition. The Contract, that is Right of Third Parties Act 1999, based largely on the Law Commission's 1996 report, brought about a significant reform of the doctrine of privity of contract. So the Act deals with the conferral of rights on a third parties, but naturally it does not alter the rule which prevents liabilities. Liabilities being imposed on a third party. It must be emphasized that the doctrine of privity was not abolished by the Act. It creates a general and a relatively simple exception to the doctrine. So Section 1 of the Act states that a third party is able to enforce a term of a contract in his own right. Of the contract expressly provides that he may, or subject to subsection 2, the term purports to confer a benefit on him. Then common law exceptions to privity of contract. In contrast to the more general exceptions on a doctrine provided by the 1999 Act, there are other narrower statutory exceptions which were introduced to avoid the commercial inconvenience caused by the privity rule. One such method is the collateral contract device, which gives a third party a right to enforce promises under a separate contract with the promissory. So in Shanklin PL Limited versus Dental Products Limited, the plaintiffs had hired a firm to plant their pier, and on the strength of a representation made by the defendants, had instructed the firm to use the defendant's paint. So the paint did not last anywhere near as long as the defendants had represented, but the contract for the purchase of the paint was between the firm of painters and the defendants, and so could not afford the plaintiff's remedy. The court held that there was a collateral contract between the plaintiffs and the defendant to the effect that the paint would last for 7 years, in case the plaintiff had furnished consideration for the defendant's undertaking by instructing the firm of painters to use the defendant's paint. So this doctrine of privity and third-party rights in insurance contract says, as we have seen, the position of the third party at common law is poor, being caught by the rule of the privity of the contract. No one may enforce all or part of a contract to which he is not a party. So this is the rule for the contracts in general, and it is also the rule for insurance contracts. For example, a person having taken a vehicle on hire, purchased and having insured it, is declared bankrupt. So the vehicle is stolen. Neither the bankrupt hirer nor the trustee in bankruptcy have reason to do what is required. But to enforce the insurance contract, whereas the finance company, which owns the vehicle and has every reason to enforce the contract, has no right to do so. The company is not a party to the insurance contract. So the another example of particular importance concerned reinsurance. If the insurer is insolvent, the insured has no right of action against a solvent parent company of the insurer or against a reinsurer with whom the insurer has placed all or part of the risk. So the general rule is that the contract of insurance and that of reinsurance remains totally distinct and unconnected. Distinct and unconnected. So therefore, there was felt a need to extend third-party rights to contracts of insurance as well as in the ways that have been discussed in the previous chapter. Previous chapter means when the privity of contract would be there. And this chapter says that the third-party right by contract are there. The usual method, if the insured wishes to extend the benefit of the insurance to a third party, is to contract not only on his own behalf, but as agent for that party, in which case the latter is third party, no longer but a party to the contract. If that cannot be done because the identity of the third party is not yet known, the solution may be to contract a composite contract for the benefit of all persons of a certain kind interested and to become interested. So if the insurer does pay insurance money to the third party payees, although the latter could not have sued for it, he may keep it unless it is shown that this was not the true intention of the parties to the contract of insurance, or the third party took the benefit solely as a nominee or agent for the insured. Unless one of these two exceptions applies, the third party is permitted to keep the benefit because it is gift which has been perfected and which once properly executed cannot be revoked. Some policies direct that the insurance money shall be paid to a named third party, such as a creditor of the insured. Such a clause, known as loss payable clause, gives no right to the loss payable unless it also constitutes or evidence an assignment of the assured's right under the policy or evidences the fact that the designated person is an original assured. So a simple form of loss pay clause, however, is not as an assignment of the policy proceeds. Such a clause purports to benefit a third party for loss pay and is subject to the rule of privity against enforcement by third party and subject to the exceptions to or evidence of that rule in the law of insurance discussed here. And then comes the avoiding privity of commercial trust. See, a person with an insurable but limited interest in goods may insure those goods and in the event of loss recover full amount of the loss or damage. Then, having deducted the amount of his own loss, he holds the balance of others with an interest in the goods. So he has been called a commercial trustee in such a case. So the solution is commercially convenient. The practice of a mercantile community as well as of underwriters has also been entirely in accordance with this view of the law, and there is manifest convenience in it. So third-party claims by express or resulting trust should be honored. In certain situations, Parliament has intervened and given the third party a statutory right of action on the policy. Some of these situations are clarified because this privity has to be seen in the aspect of the individual contract. So another difference in India and UK law in this regard is that the third party rights in the UK have been recognized and implemented in a vast number of insurance fields. In India, however, the jurisprudence has evolved only in the field of motor vehicle. However, seeing the benefits of conferring third party rights in the insurance contract, there is a clear need to impose the same in India in a big way, especially in life and property insurance. Thank you. Thank you.